This is Agriculture Today. We are back with our ag law update from Roger McEowen. He is a K-State and Washburn University School of Law professor. So, Roger, thanks for joining us.
Good to be with you, Samantha.
Absolutely. So today we're going to cover really a dicamba legal issue that we've seen over time occur in different cases. But when it comes to dicamba, what actually makes a strong case in these sort of legal avenues?
Well, spray-drift cases are not uncommon. Those with dicamba have been occurring for a number of years, and it's because of the reformulations of dicamba and EPA kind of getting out ahead of itself in terms of having the technology down and then having information out to farmers in time to use the new formulations. And dicamba, especially under heat in certain conditions, is very volatile, and it can spread several miles. And we've had issues, particularly with respect to soybeans in recent years, but there's one case that has come out of the southeastern corner of Missouri, just north of the Boot Heel area, involving a peach farmer that has really kind of been one of the lead cases on this throughout the country.
Yeah, and let's touch on that peach farm case a little bit more, because from what I understand, this is a large case.
Right. This is the Bader Farms litigation that's been going on for a number of years, and the peach farm at issue is Missouri's largest peach farming operation, down, as I said, near the Boot Heel corner of the state. And that farmer claimed that his peach orchard, and again, when I say orchard, just don't think something out in your front yard. This is massive. He claimed that his peach orchard was destroyed after Monsanto and BASF allegedly conspired to develop and market Dicamba-tolerant seeds and Dicamba-based herbicides. And he alleged that both those companies collaborated on Extend, which was a herbicide resistant, intended for use with a less volatile form of dicamba with less drift potential. But his claim went on. As of 2015, neither Monsanto nor BASF had produced the new, less volatile form of dicamba, and so that led him to claim that those companies had released the dicamba-tolerant seed without having any corresponding dicamba herbicide that could be safely applied. So he claimed that farmers in the area were illegally spraying an old formulation of dicamba that hadn't been approved for in-crop over-the-top use and was highly volatile and prone to drift. And he claimed that he had serious economic loss. His annual peach crop revenue exceeded $2 million before the drift damage, and his expert at trial asserted that the drift caused him to lose over $20 million in profits. And that teed it up for the court.
Absolutely. You mentioned the volatility of this product and how it has the ability to spread to neighboring fields, and that's kind of why these cases are hard to prove in some ways, right?
That is a point, and it's the same issue that we have in many types of pollution cases where you claim that a firm is negligently polluting a river, but there are numerous firms along the river. Where is that pollution coming from? Well, when you get into herbicide and pesticide drift cases, sometimes you're able to pin it down more accurately because of the type of damage that occurred is particular to that particular type of herbicide or pesticide. So that is a little bit different in these cases. If you have numerous farmers that are using the same chemical, it can present proof issues, but there was no doubt that he had substantial economic loss, and there was no doubt of who the companies were that were producing the chemical at issue. And so he was able to pin it down to those companies. He wasn't suing local farmers, but he was suing the manufacturers of the product.
As this case continues on, what can we kind of expect to see?
Well, the company's motion to dismiss the case, claiming that failure to warn claims and violations of the federal Fungicide Rodenticide Act, there were preemption of those claims that was involved. And the farmer in return claimed that there was no warning that could have prevented the damage to his peaches, and therefore the federal law couldn't have preempted his claim. There were also negligent-based claims in the case, but both Monsanto and BASF moved to dismiss the negligent-based claims. And the trial court wouldn't dismiss those claims, but the trial court did dismiss a Consumer Protection Act alleged violation under Missouri law claim. That one did not go on. So it goes to the jury. The jury came back in this one and came back with a very big damage award, $63 billion. what Monsanto and sued for in about 100 lawsuits across the country. Monsanto had then subsequently been acquired by Bayer, and Bayer announced that they would settle all the Dicamba lawsuits for $400 million, but this case was outside that. So this one moves on. The jury came back and awarded the farming operation $15 million in compensatory damages, $250 million in punitive damages, goes on appeal, and basically the most recent development out of the Eighth Circuit is that the compensatory damage award of $15 million is upheld, but the $250 million, which had then subsequently been reduced by the appellate court or an intermediate court, was eliminated because those damages were not calculated properly at the jury trial level. So it doesn't mean there won't be any punitive damages. It just means the case continues. It's on remand back to the trial court for a proper computation of what the punitive damages would be to be awarded on top of the $15 million in compensatory damages.
Wow. Well, like I mentioned before, a huge case indeed, and one that I'm sure we'll continue to follow up with and see where it goes. But in terms of another topic of interest, there's been a change for corporate minimum taxes. Can you tell us a bit about that?
Yeah, this is in that so-called Inflation Reduction Act. I hesitate to refer to it by its name. I think that's kind of a misnomer, and just about all economists agree on that. But there is this tax in there, brings back the quick, but it's on book income. It's a little bit different. And what it is a 15% corporate alternative minimum tax that's applied to adjusted financial statement income of corporations with profits exceeding $1 billion. Now, that may seem like a very large number. It's not really when we think of the major manufacturing companies in this country that employ lots of people. Some of the nation's largest employers are going to be working for companies that will get hit with this. So the corporation is going to be subject to this, and they could claim net operating losses and tax credits against it, but if they're subject to this, they're going to have to pay it in addition to regular corporate tax that would otherwise apply. So it is a corporate tax increase. It will filter down to purchasers of products because it will get cooked into, so to speak, the price of goods that those companies manufacture. Corporations don't, in essence, in reality, they don't pay tax. They just build into the price of their products. So that is something to look at. Now, there are a lot of other spending provisions in this bill for conservation-type programs and renewable energy and those type of things. Some are extension of existing credits. Some are creation of new types of tax credits. So, again, from an economic standpoint, here we have more spending, throwing more money into the economy. That will have the opposite effect of reducing inflation. Will tend to put more pressure on inflation to increase. But this corporate AMT is something we want to keep our eyes on.
Absolutely. Like you said, something that could have impacts on prices as we go ahead after we've already been experiencing inflation for quite a while now in the country.
Yeah, we've gone through 2 quarters of reduced GDP, which is the classic economic definition of what a recession is, and inflation month to month, while it may be down over the most recent month compared to the percentage increase, there's still a lot of inflation in the economy. It's just we go from 9% from the same month a year ago to, say, 8% the same month a year ago. That's still an increase, but it's an increase at a lower rate. So, yeah, it's still tough on lots of people. It's particularly harsh on the middle to lower income people in the country. And a lot of that is traced to energy policy, which gets factored into the production of food. Diesel prices high. That increases the cost of producing that food by our farmers across the country as well as in Kansas. And that's a big part of what's happening in the economy right now. So from my perspective, not a good time to be increasing taxes on corporations, which will end up being reflected in higher prices in products, including retail food prices, too.
Absolutely. And Roger, if people are tuning in and they're wanting to know more about the cases we've covered today, so whether it was that Peach Farm case from earlier or if it's these corporate minimum tax changes, where can they find that at?
Well, there are really 2 places. The first place would be my blog, which can be accessed through my homepage on my website down the left-hand side. And then many of those also I share with Ag Manager through the Ag Econ department, and they'll be rerun on the Ag Manager website also.
Absolutely. And as always, those links will be in the show notes of today's program, which can be found on agtoday.net. But Roger, as always, we thank you so much for your time.
Thank you, Samantha, good to be with you.
Yep, you as well. Once again, that was Roger McEowen. He's a professor here at K-State as well as the Washburn University School of Law, providing our Ag Law Update.